Great. Wonderful. Good afternoon, everyone. If it is an afternoon for you in East Africa, it surely is. If it is a morning or evening anywhere else around the world, we are happy to have you to this in this webinar, this session, and very exciting one. It starts up on a very good note on days when we have the world's biggest football showpiece taking center stage. Last night, it was Mexico against South Africa. A very good one, very good start it was. If you enjoyed it, like I did, there were more red cards than the goals scored therein. Nonetheless, the hosts, Mexico, picking up the opening day's points, with South Africa, of course, with much work to do in their group. Nonetheless, the World Cup also has its arbitration process. An ad hoc committee was set up by CAS, the Court of Arbitration for Sport. Well, very interesting things there. Of course, that forms part of the discussion we shall have today in what is a very strong webinar on the practical insights into sports arbitration in Uganda and elsewhere in Africa. Ladies and gentlemen, you are welcome to this. I am Leon Senyange. I will be your moderator for the day. Now, this session has been brought to you by the Chartered Institute of Arbitrators Uganda chapter. Well, what do? Of course, alternative dispute resolution, arbitration, mediation, adjudication, ADR, dispute resolution, ADR trainings. And of course, here in webinars, this kind of interactions make a very big difference to the understanding of ADR in all spaces of life. There are socials you can follow. Chartered Institute of Arbitrators Uganda chapter on X, formerly Twitter, LinkedIn, YouTube, and Facebook. This session is being live streamed. You can also follow that later on for future reference on YouTube. Just as much, with your spare time, you can jump into the website therein and get a lot more about what SIAB does. Now, sports is a big thing. You play chess, football, badminton, and more recently, paddle, that one, and a couple of others. But soccer, of course, cuts through as the biggest, but even many others that come through in our daily living. But it forms big conversations when the disputes arise. And of course, the intersection of sports and alternative dispute resolutions is increasing across Africa. For Uganda, of course, there is a new law that now provides for arbitration. Very, very good space to dive into. This afternoon, we'll of course explore the growing role of arbitration in resolving disputes in the sports sector. We'll listen from, well, experienced gentlemen therein to tell us more about sports governance. How does ADR or arbitration in the sports sector work? Where did it start? How is its operationalization in Africa, in Uganda? What is it like elsewhere? And these are things we'll be diving into later this during the course of the 1 hour and a half, possibly 2, that will be together. The speakers for the day, ladies and gentlemen, Mr. Ivan Ojakol. Mr. Ivan Ojakol is a partner at Matrix Advocates. He is a member of the Chartered Institute of Arbitrators, an arbitration practitioner in the commercial and sports space. Ivan previously taught ADR as a lecturer at the International University of East Africa. He is actively and currently sits as a sports arbitrator locally before different sports tribunals and has appeared as counsel for a number of leading sports personalities in Uganda before arbitral bodies. He is also, he has in the past served as an arbitration tribunal secretary for a retired judge and has undergone world-class arbitration mentorship programs under the Association of African Young Arbitrators, AYA, and the Institute of Transnational Arbitration. Ivan, or Mr. Ojakol in this case, has published author in the field of arbitration, especially sports arbitration. He has also served as an arbitrator in the National Sports Arbitration Moot in Uganda. Very exciting. Our second speaker for the day, Mr. Timothy Kaja. Mr. Timothy Kaja is a sports lawyer, a FIFA licensed agent, and a badged sports safeguarding officer. He serves as a lecturer of law at the Uganda Christian University, Kampala International University, and Chambogo University, where he inter alia lectures sports law. He is an associate partner at Ngoro Mutebi Advocates. He is a consultant with the World Bank as well. TK, as we quite often call him, is the managing director of Discovery Sports, a sports business firm. TK, his father serves as the legal officer for the Kampala Capital City Authority Football Club. He has worked on a number of high-profile sports projects and instructions capturing entities such as the FA English Premier League, the African Games, the Olympics, the United Nations Alliance of Civilization. He is also a member of SIAB, specializing in sports arbitration. This is an exciting one that's coming. He represented Fahad Bayo, the first Ugandan to win a case at the FIFA tribunal against a European club in international sports arbitration. He is the chairman of the Young African Leaders in Sports, YALS Forum, a body working under the Africa Union Sports Council. TK has also served as an arbitrator in the Football Law Annual Moot, a continental sports arbitration moot therein, the Sports Arbitration Moot in Spain, and also he is the founder of the National Sports Arbitration Moot in Uganda. Ladies and gentlemen, you are welcome to this webinar with an exciting lineup of speakers that will be taking us through what we have to understand about sports arbitration here today. Brief housekeeping rules. If you have any questions, I'll be glad that you put them through the chat box. Later on, we shall have sessions open for the voice questions, and we'll be glad to listen to what you have to say, or if anything, your questions. The session today, the practical insights into sports arbitration in Uganda and elsewhere in Africa. I'd like to welcome Mr. Ivan Ojakol to run us through his presentation, which will talk about sports arbitration in Uganda. Later on, we'll hear from Mr. Kaja on the general perspective of sports arbitration. Mr. Ivan Ojakol, the floor is yours.
Thank you very much, Leon. I hope can you see my presentation yet?
Not yet, but your screen is on. You could just click on your presentation. It was up earlier.
Is it on now?
Yes, it's now on.
Oh, thank you. Thank you. You've never lost your journalistic touch from the time, without exposing my age, from the time I watched you on TV back in the day. Ladies and gentlemen, my name is Ivan Ojakol. I thank Leon for a very exaggerated introduction, but nonetheless, I'm happy to be here and share these nuggets of wisdom with you. The topics are divided. I'll handle the sports arbitration as far as a Ugandan perspective is concerned, and Timothy will later on take us through what is happening elsewhere in Africa. But without a doubt, because it is a nascent area in Uganda and developing, there's no way I will not also mention some things that are happening elsewhere, because those things should be able to inform what I believe is not yet really in place and is still in paperwork. It should be able to inform an envisaged sports arbitration. As far as I'm concerned, it's still futuristic and not really running. What is running right now maybe is some ad hoc arbitrations here and there, or some goodwill ADR mechanisms as far as sport is concerned. So, of course, we all know, I believe, on this call, and I'm sorry for being presumptuous, perhaps we know what arbitration is, and I believe we do know what arbitration is, and to avoid wasting time, it is an ADR mechanism in a nutshell. That is where a dispute, usually arising from a contractual agreement or provision or clause, is subjected to a third party who gives a binding decision that is enforceable. That is arbitration generally. And arbitration being an ADR mechanism, and it's important that we mention the word ADR because a lot of this term arbitration is thrown around sports, but as far as I'm concerned, and I'm sure even Timothy and Leon and whoever is on the call, a lot of what actually happens is more or less ADR, not really arbitration in a strict sense. But because I think it's fashionable, because of a certain body which I look at called the Code of Arbitration for Sport, to mention the word arbitration in line with sport. So it's also important to talk about the ADR mechanisms in sport. So it has, the revolution has taken root largely because of that body called the Court of Arbitration for Sport, and everyone is now trying to, in one way or the other, incorporate arbitration as far as their resolution of disputes regarding sports disputes is concerned. And with the emergence of this thing called CAS, the Court of Arbitration for Sport, it engendered something called a compulsory arbitration, otherwise known as a mandatory or statutory arbitration. Now, what that means is that away from what we are trained, us who have gone through CAB trainings and people who have been trained elsewhere through other education providers, as far as arbitration is concerned, or in school or whatever, you are told that there must be a meeting of the minds of the parties through a clause or a contract, in line with the principle of arbitration called party autonomy. The parties must agree to that particular provision. But here is a provision that is more or less being dictated upon that particular sport. For example, it's football. They'll say, our disputes shall be resolved through arbitration. Remember, a footballer in the village, or a member of KCC, or a member of Pirates Rugby Club, is just, I mean, he's on his frolic. He's really, as far as he's concerned, he just wants to play sport. But there are people who have said that this is our binding constitution, our binding law, and these are the rules that if you have a dispute, you will go through arbitration. So it engendered that thing called compulsory arbitration. It comes with its own problems, as we shall see later. And perhaps that is why a lot of my presentation will be more or less a critique of what the law says as far as arbitration is concerned under the National Sports Act in Uganda, and what I think we can borrow from elsewhere and how we can improve. It's important that we go through the advantages of ADR, and it's those advantages of ADR and arbitration that perhaps in the first place attracted the sports world to arbitration. Procedure flexibility, you can determine the rules of procedure, speed, quick resolution of disputes. Imagine the World Cup being put at a standstill because someone is fighting over, say, whether, for example, you see how I'm sorry for mentioning this on this call, the geopolitics of the day, USA, Iran, and whatever is going on. Imagine the World Cup being put on a standstill because of that. And we have to wait for some judge somewhere to come up with a decision. But ADR and arbitration come with all these benefits: expert determination. You have sports law experts, people who are experts in that field. The list of the CAS arbitrators, I can assure you, if you went through their CVs, many of them are either highly experienced qualified arbitrators or sports lawyers who have been practicing for a while. Confidentiality, that's another very interesting one that you should take note of. And perhaps where arbitration as far as sport will tweak it a bit, and we shall see. Cost effectiveness, some people are saying it's no longer cheap, but the right word to use is cost effective. For a long time they say ADR is cheap, but the right word is actually cost effective. As you know, arbitration, and that is one of the criticisms that has got quite expensive. But the cost effectiveness is the fact that you have an expert who's going to resolve your dispute very, very fast and save you from a lot of money. Something like that. Finality and enforceability. Sports arbitration, like all these arbitration models elsewhere, you can enforce an arbitral award the same way you'd enforce one under the New York Convention. If say it is determined at CAS, where the seat is in Lausanne, in Switzerland, you can come and enforce that very arbitral award in Uganda. For example, how Timothy is now at CAS. I think the Fahad Bio matter was appealed. I think he will tell you more about it. Eventually, when he gets his award, he can enforce it at wherever. I forgot the club. I think it's a Czech Republic club or something like that. He can go and enforce it, even if CAS will have determined the matter in Lausanne. Preservation of relationships is very important as far as sportsmanship is concerned. So those characteristics inherent in arbitration and ADR are what attracted the sports world to arbitration. But also, like I mentioned, there's a bit of tweaking. There's a bit of tweaking of arbitration principles. There's also a bit of tweaking of ADR principles and what they are, as far as sports arbitration is concerned. And largely, that is rooted in certain sports law concepts and also just a unique nature of sport. It is a very unique industry because one, you have sportsmen with very short shelf lives. You have tournaments that are ongoing right now that must take place at particular times. There are match calendars which FIFA comes up. There are season calendars that FIFA comes up with and say the World Cup will be held every 4 years. There's a Champions League towards the end of May. So that consistency must be maintained. And it's because of that ADR now comes in handy. But a lot of that is rooted in what sports is. There's something called the autonomy of sport, a principle basically saying that sports bodies, in the regulation and governance of their sports, should be free from government interference, should be able to handle their disputes internally, away from court intervention and what have you, among others. Specificity of sport, some people have argued it's quite a very ambiguous concept, but by and large, again, it comes back to what I talked about earlier. Specific aspects, characteristics of sport, which have even made the law so kind of be bent towards or be tilted towards the unique aspects of sport in order to be able to handle that. So it's because of things like those that ADR now comes in hand. And also just the nature of disputes, eligibility. Someone wants to play at the World Cup. They want that dispute resolved right now. It's a matter ongoing, like Cass and Timothy will talk about this later, has an ad hoc division currently at the World Cup. In case any quick dispute comes around, they resolve it. People have argued that perhaps if we had a CAF or even a CAS ad hoc arbitration division at the recent African Cup of Nations, perhaps we wouldn't have had the scandalous things that have happened since regarding the final. So those unique aspects of sport, unique aspects of ADR married and developed a dispute resolution mechanism bespoke to sport through sports arbitration. It has come under attack, as we shall see, and increasingly nation states are fighting back. As you know, sport has developed. It's no longer just recreation, games, fitness. It's now a huge commercial industry, almost $1 trillion industry. So as you can see, all of these principles of sport, of of arbitration, party autonomy, independence, impartiality, limited judicial intervention, confidentiality. They're all important for this particular discussion. There are others, but these ones I picked them out because they're important for this particular discussion. How does party autonomy work when it comes to sport arbitration? I've already talked about mandatory arbitration. So it is not strictly party autonomy, the way you understand it when it comes to commercial arbitration. Independence and impartiality, and this becomes very important for Uganda's arbitration legal framework and regime. Limited judicial intervention. The arbitration framework in Uganda attempts to keep out the courts. Can they do so successfully? And we're going to see this. Confidentiality. Arbitral awards, unless with the argument of parties, should not be or cannot be published. But sports, because of its public nature, people are interested in what's happening to their sportsman. It sort of creates an exception for that. Not all sports arbitral bodies, but for example, CAS publishes its decisions. The SDT in Kenya publishes its decisions, and a couple of others. And you'll see why. I've told you, because of the nature of sport and its specific nature, certain things have been tweaked to favor sport. But let's go back to the foundations. I mentioned this body called CAS. So CAS was formed by the IOC in 1984. Interestingly, it was an African person who's not mentioned a lot who was at the helm of it. He was an ICJ judge, International Court of Justice, Judge Kemba Mbaye, a Senegalese. He was the brain behind CAS. And I've been trying to do some writing on the legacy of Judge Kemba Mbaye. When my publications are ready, I'll share them. So CAS, IOC comes up with the CAS. The great Antonio Samarak, who was the president, then described it as the Supreme Court of Sport. The apex court, literally, of sport. But over time, through the years, as it had started gaining its footing, it started getting some resistance and criticism. Again, remember, because it was formed by the IOC, athletes were like, okay, IOC appointing arbitrators, isn't this going to be is this going to be an impartial or independent tribunal? What are the chances that I'll be able to prevail over a sports governing body when I take them on? So someone went to a Swiss Federal Tribunal. That's a very important court for you to note. What does that mean? What does the Swiss Federal Tribunal, and how does it come in? So basically, and this is a bit of a controversy around sport, CAS is found and created in Lausanne, Switzerland. So the seat of arbitration is in Switzerland. And like we mentioned earlier, one of the principles of arbitration, especially if you base on the model law, but I believe just about every law, is there's a limited and agreeable judicial intervention in certain circumstances. For example, when it comes to, say, matters concerning the law, matters collecting evidence, setting aside procedures, among others. The courts can come in somewhat, even interim measures, among others. So the seat is in Lausanne. So these guys decide to take on CAS in Switzerland. That's why they went to the Swiss Federal Tribunal. The court was not convinced that CAS was not entirely not independent, and found that it was actually sufficiently independent, though it made recommendations. When it made those recommendations, the guys at the apex of running CAS and IOC etc. came together and decided, you know what, through something called the Paris Agreement, and decided to, let's create as much goodwill for this court and as much as possible be transparent. So they created, for example, the two divisions, the ordinary division and the appeals division. That has now also been extended. There's a division that handles anti-doping matters regarding banned substances and what have you. So they tried to reform over the years. However, those criticisms have not entirely gone away. They are still there, and shall see this with the jurisprudence that has come out. So compulsory arbitration, just for emphasis, again, is a forced consent, for lack of a better word. It's a famous case of Paxton, and this Paxton is a very important person as far as CAS is concerned and sports arbitration, and shall see later through a famous case of Mutu and Paxton, where they took on CAS. So a German judge said that it is a forced consent determined by others. So how can you participate in an arbitration, a private law dispute resolution mechanism, where you don't really express your consent? Very, very controversial, right? Yeah. So, but for sport, because of its uniqueness, people had thought that maybe, for justifiable purposes, uniformity, predictability, certainty, and in order to just ensure that the whole world is at par. We're all participating in a World Cup. We're all participating in Olympics. Please, let's be at par as far as our legal systems regarding sport are concerned. Of course, remember for a very long time, these guys operated under private law mechanism, literally a parallel legal system away from nation states. That has been poked recently, but yeah, they still many times maintain and to some extent say they're independent. Remember the principle of autonomy of sport. Even in our Sports Act, it's there that they're independent, which really is the jury is really out there. Yeah, so compulsory arbitration, I just put this slide for us to properly understand what that is. Some of us are arbitration minds 101, and we wonder how an arbitration can be forced without, you've been told party autonomy, what? People must agree and sign. So, very, very interesting. Here is the dictation of a dispute resolution mechanism. So I mentioned Paxton. Paxton was a swimmer who was not happy because she was banned over some substances by the international. No, she was a skater by the International Skating Union. So she took them. She took them out. She kept on losing. She lost at CAS. She lost at the ICU judicial bodies. Went to CAS, lost again, but she was not satisfied. Then she met a one Mutu. Those of you who have been football fans for a long time, I know Timothy, he may be a bit younger than me, but I know he may have watched a bit of Adrian Mutu. Adrian Mutu was literally, I think, the first signing that Roman Abramovich signed when he had just taken over Chelsea. Brilliant footballer at the time. Brilliant, brilliant footballer. He was set to set alight the English Premier League, but the guy gets into some problems, cocaine, what? He's banned, and he also fights. Now they combine somewhere and they're like, okay, we have been beaten through the whole judicial system. Let us find somewhere else to go. So they got a loophole. Remember, impartial tribunal. Sorry, one of the principles of arbitration is the impartiality and independence of the tribunal. So here is Gundel coming back and the criticisms of the original foundations of CAS. Of course, Semenya too, after she lost, remember her, people call her a man, what? But, and that argued that because of her extra testosterone and what have you, it gave an advantage when it came to racing. So she took them on, lost through the process, lost at CAS. But then there was a loophole they saw. The European Court of Human and People, it's called the European Court of Human Rights. So there's a convention, the European Convention on Human Rights, which states that in judicial processes, tribunals must ensure and guarantee a fair hearing, a public and impartial hearing. Same as our constitution here in Uganda, right? So they jumped on that. And the argument was, we are not involved in agreeing to this arbitration process. What if I want my matter taken to court or to mediation? Oh, I don't know where else, another dispute resolution forum. These guys are forcing us to go to CAS. We have never agreed to this. There's no clear intention for us to arbitrate. And just like that, they got some loopholes. Interestingly, CAS has not really changed even after the pronunciations of the courts. Courts said that because their systems are a bit opaque as far as consent is concerned. They even said that yes, even with Gundel and what have you, Still, many arbitrators are. Their names are forwarded by sports federations and not abuse, so that can still create bias in one or the other. And also public hearings. Again, remember, arbitration is supposed to be confidential. But here is a court telling an arbitration tribunal that they should be public. These are international, national athletes. Very, very interesting, right? Around that time, CAS succumbs to some pressure. Some Chinese is also involved in some doping issues and the politics of China, and I think also USA comes in, and they decide to conduct his hearing public. The English decide to have there's a whistleblowing case about racism. The board, the cricket board, decided to have a public hearing of that dispute. So you can see there is a bit. So the impact of the court, and we're going to see the role of these regional courts in Europe, and perhaps that's what you should also. And I know Timothy wrote his master's thesis on this. The role of regional courts in as far as advancing sports law is concerned. The role of the courts in Europe has been amazing. They have advanced sports. Some people have criticized that they've overdone it and overstepped their powers, but some of those things have come through because of course. So already we are seeing impartial tribunal, independence of the tribunal. CAS is being questioned. CAS, that is supposed to be a Supreme Court of sport, has done so many good things, but people are still not satisfied. We are seeing confidentiality issues. Arbitration should be confidential, but here are people publishing awards. Or people demanding that their awards be published. That then leads us to another case again. Now the CJU, of course, the CJU even before this case had pronounced itself on a number of other issues again. But again, literally the same point, especially on competition law, as we shall see later. Now in Serang, this guy also goes ahead and questions the impartial, but for him, he goes to the CJU instead of the European Court of Human Rights. Now here the court says that because we are suspect of the impartiality of that case, it is important that national courts, in limited, we mentioned earlier one of the principles of arbitration, limited court intervention, meaning on a few procedural aspects here and there, appointment of an arbitrator where one has failed to be appointed, interim measures, helping in collecting evidence, among others. So a few limited things. But here the court is saying that beyond that limited review, there should actually be a heightened review of CAS awards to ensure that they pass the tests of a fair hearing. So it's not enough for you to say, okay, you had a lawyer, okay, hey, you fair hearing. Go and see what exactly happened. Literally digging into so many things. It's more or less digging into the merits, which is unheard of in arbitration. So controversy again, we shall see how these things play out, but the courts are being very, very strong in calling out this private dispute resolution body called CAS and sports arbitration generally. And why I'm going through these things, because let's be honest, the global standards as far as sport and literally many things in the international world come from elsewhere, then the rest of us, literally copy word for word, and those things become binding on us. But some of them are for the good, as you see, because and I'll discuss later when it comes to our sports federations, the guy will say, we are banning you because you have taken us to court. But is it outright that whoever goes to court has gone there illegally, even when the rules say not go to court? And I'm going to advance that argument later. Competition law. This one has literally bogged down international sports federations. It is trite in arbitration again when it comes to mandatory laws that they must be followed, especially when a seat has certain mandatory laws. And that's another argument because it's not necessarily that, because many of these federations are housed in Europe, especially Switzerland. And Switzerland is not really is not a member of the EU. Yeah, so there have been those arguments that why you strictly bring these strict EU standards to us, and yet Switzerland is a very liberal society or economy when it comes to ensuring private bodies enjoy as much autonomy as much as possible. Maybe Timothy will discuss those things. But yeah, there have been a number of competition law cases because naturally, in competition law is what they call a dominant position. A federation, because it is the regulator of the sport, has naturally a dominant position. It's the one that determines the rules. And especially now when it goes into it's a federation, but it's also going into the commercial aspects. It's a federation, but it's also selling jerseys. It's a federation, but it's also organizing tournaments and getting money from these big corporates, the callers of this world. So the law, as far as competition law is concerned, is that it is not necessarily illegal to have a dominant position. But when you abuse it, and European Super League, remember, the big European clubs have tried to set up a parallel league like the UEFA Champions League to run their own show, and UEFA had threatened them and come down hard on them. But they went to court. They went to the CJU, and CJU said because UEFA had not justified why it was coming up with those funny rules that it was using to scare these guys, there was no objective, transparent, proportional criteria. It therefore was in the wrong, and these guys can actually go ahead and organize the tournaments. I think what saved us sports fans was the fact that the fans rose up and made noise and like, no, you guys cannot do this, you're being selfish. Then eventually the big clubs abandoned it. I think the likes of Arsenal, my team, even apologized. So there's also a Mecca Medina test around 2006 that also determined what amounts to proportionality when it comes to rules of or decision-making power of sports bodies. I am now moving from independent tribunal, confidential, our original foundational principles of arbitration, confidentiality, limited court intervention, to court intervention. Is it limited? Is the question. Well, maybe we can properly place it under limited court intervention. So the UK has a bespoke arbitration mechanism. It is also very, very interesting because that's why their disputes don't end up at CAS, because they have a final internal dispute resolution mechanism when it comes to their disputes. So they call it arbitration, but this was a disciplinary proceeding. So that's another thing, by the way. From experience, you find that a sports body says everything for them is arbitration without necessarily defining and properly setting out the rules. Remember, arbitration is a procedural thing. For example, the way we have the Uncitral Model Law, the way we have the English Arbitration Act, it sets out procedure. But meaning it should be properly laid out in a legislation, a proper thorough legislation. And this is another discussion I'll come back to later. But you find many of the guys saying arbitration. It says disciplinary hearing. Is a disciplinary hearing necessarily the arbitration? I don't know. But they will label everything arbitration. Now the English actually decided, you know what? Even for disciplinary hearings, we shall call them arbitration. And for them, they properly laid out the rules. Now, Bradley had been, I think, thrown out by this jockey club. He had argued. He took them on in court. But because Bradley, remember the principles of judicial review, it must be a public body. Or, as Ivan Magoma has shown us, and I'll discuss later, a private body exercising public roles or roles of a public nature. For example, sports federation, you're governing a sport. Yes, you are created privately, but now you're public. But also now with the new Sports Act, National Sports Act, it is arguable whether they are still private. They're no longer private as far as I'm concerned. They're now going to be registered by the government. So yeah, I think the arguments on judicial review failed, but the court pronounced itself that even in circumstances where it was a private body entirely, we still had some level of review as far as the process is concerned. Yeah. So yeah, but now you're going to see how this now plays out when it comes to a private body exercising a public good. You get the point. It's like Kampala Club. Kampala Club is a private body, really. I think there's even a case on this point. But when it comes to a private body exercising a public good, I think even the judicial review rules of 2019 capture this. It then applies. So please read up on jockey. I have so many slides. I'm trying to rush through them. Sorry. Now, we have seen that there's some level of intervention by the courts. Of course, naturally, for every arbitration, like I mentioned, but remember, our act says matters shall not be taken to court, sports matters. But it does not properly define what a sports dispute is. Like I mentioned, sports over time, because of the development of the sector, there are varied sports disputes. It can be an eligibility, it can be a governance dispute, even things like image rights. And that is very controversial in line of a Pauline versus Fufa case, because Justice Mubiru seemed to say that for those ones, they should go to a normal court, not even a sports tribunal, because they are rights. And increasingly, the jurisprudence elsewhere seems to say to differentiate between a rights-based dispute and an interest-based dispute. Rights is, for example, like a judicial review, they didn't give me fair hearing, and therefore went to a national court. An interest would be, for example, a sponsor, and you've not come through as far as your part of a bargain is concerned, or they have not paid or whatever, then that's an interest-based dispute. So it does not even define this dispute, and that's another challenge we have. Yeah. So I've laid out some relevant provisions as far as our arbitration mechanism envisaged under the law is concerned. Decisions are final, and that is trite when it comes to arbitration. No intervention of courts, but of course I've argued that courts can intervene. But again, I'm going to argue it further as we proceed. That the Arbitration and Conciliation Act can apply with necessary modifications. So the guys failed to come up with proper rules. If you go to Regulation 33 of National Sports Act regulations. They have not properly come up with thorough, comprehensive rules, robust rules that can help us. They've instead referred to the Arbitration and Conciliation Act, which is based on the UNCITRAL model law. You guys, I believe many of you are either associates of CIAB or members of CIAB and have gone through some sort of arbitration training. The UNCITRAL model law was aimed at commercial arbitration. And I actually have a copy of it here. I just want to read for you the preamble on scope of application. This law applies to international commercial arbitration, subject to any agreement in force between the state and any other state or states. So the law refers to international commercial arbitration, but you're bringing a unique sector, which, yes, is amenable to arbitration and allows it, but has its unique bespoke aspects, which have sort of tilted or have sort of had arbitration refined towards its unique aspects. That already is a major conflation of issues that is going to cause problems. UNCITRAL model law is being referred to as more or less a procedural law. And this, Timothy and I were in the committee stage of before this law came into force. And I remember the Attorney General saying that because of the rationalization of government agencies, we could not risk having an independent sports tribunal. The government did not have enough money. And I remember him saying that the Arbitration and Conciliation Act is enough. But I think that was wrong. And I'm justifying it here because this is it's a different area of law. Yes, similar, it's arbitration, but it has commercial arbitration and sports arbitration have some convergences, but also are not entirely similar, as I've mentioned. And this we can have another discussion if you want. Arbitrators are appointed from nominations by council and national sports associations. Back to the argument of Gundel and CAS arbitrators being biased and being impartial, not being impartial. The fact that sports governing bodies are ones nominating and appointing them, among others. So are you seeing how we are falling into that trap of, and this is the thing, and I'm sorry to say this. This is why sometimes it's important to have subject matter experts on some of these things. But I know sometimes I don't listen to. But I've given you, for example, a background on how some of these things are developed elsewhere. And the sports world being international in nature, we cannot attempt to work in isolation and come up with our own things because we risk so many things as far as sport is concerned. So those things and these provisions as far as sports arbitration are what are in the act, but do they necessarily pass the legal tests of what can create a proper sports arbitration mechanism? Of course, those read together with 17, it says independence of sports bodies, and 18, which says affiliation sports federations. 18.4 particularly says the interpretation and application of the act recognizes the provisions of statutes and regulations of international federations. Keyword recognizes is a deliberate use of language. It's not saying we are bound. It's not saying we just recognize them. That's very, very interesting, and it's very deliberate. And why it's deliberate, a proper reading, a whole reading of that Sports Act is an attempt at making sports law more local than international. But like I said, sports in its dual existence nature cannot be really local, more local than international. If anything, we actually should be more international than local. And that's why, for example, it's even problematic legislating on sports because you risk falling under all kinds of traps. If someone wanted a law, I just fast tracked it. And now we are all of this problem. But you know, this act was amended, but it was amended back door. It didn't even properly go through the provisions. IOC said, we're not satisfied with your anti-doping provisions. You get banned. Therefore, put these provisions in. It was not proper followed through a proper public participation process. Anyway, that's another discussion for another day. So for me, back to my discussion, and I'm using the foundations of arbitration and what has happened elsewhere as what should define whether those provisions that I've just read pass these tests. Do these provisions pass the international sports law legal tests? People are saying CAS is biased. For you, you're saying the National Council of Sports will appoint arbitrators with nominations from sports governing bodies. Is that really a proper arbitrator? What happens when Ivan is taking on FUFA or FIBA or FUBA or, do they pass constitutional muster when you say shall not go to court, unlimited jurisdiction of the High Court? Has it been entirely outlawed. Leg specialists, but leg specialists should be very thorough and clear, and there's a case which I'm going to refer to later on. By referring to the Unsuto model law, is that proper? A commercial arbitration legal framework. And when you say that not amenable to court, when you cannot go to court, yet there are rights aspects that can have someone invoking judicial review or even the Human Rights Enforcement Act. Are you sure you're going to defeat that? Already Ivan Magomu and Nsamba, as we shall see later, have said that sports bodies can be taken, especially when it matters of judicial review. Because there's even a case, I just didn't put it here. Someone went under the Human Rights Enforcement Act. He had been kept out of meetings of his sports federations, and he won. I think the decision should be by, she's now at the Court of Appeal, forgetting her lady. She was at the Civil Division, her lordship. So, in not defining a sports dispute alone is already a problem. Without a doubt, this act will need to be amended at some point, or bespoke regulations will have to be adopted. But why I'm saying this is because I'm informed that the regulations that were released for now are going to be the regulations we're going to work with. But as far as I'm concerned, they're not robust and comprehensive enough as far as covering some of these things are concerned, like sports arbitration. Justice Mubiro has told us in Pauline versus FUFA and MTN that some sports disputes should not even go to a sports governing body. A sports governing body's internal tribunals. It should go to the High Court because that's a rights thing. Right of personality, image rights. This is the case I wanted to quote Justice Mulenga as he then was in Harbour International. The tendency to interpret the law in a manner that would divest courts of law of jurisdiction too readily, unless the legal provision in question is straightforward and clear, is to be discouraged. Since it would be better to err in favor of upholding jurisdiction than to turn a litigant away from the seat of justice without being heard. You try and invoke an international arbitration mechanism of a sports body. The guys do not even have an arbitrator. They don't have arbitrators readily in place. They perhaps will dodge if you write to them. They will be as uncooperative as much as possible before you know it, you're in a court of law. It is because you've tried to exhaust the internal mechanism or internal remedy, but it was unavailable. And that is allowed as far as matters concerning rights. Even in international law, once there is an international remedy provided for, but it is unavailable, you can move to the next stage, which usually is the High Court. I want to state here unequivocally that the National Sports Act has not taken away the jurisdiction of national courts in handling sports disputes because it is not thorough and clear enough. And like Justice Molenga says, it is better to err on the side of caution than turning a litigant away from the seat of justice without being heard. So there are two cases. There could be others, and I think they have been there over the years, like the Pauline case of 2009, Pauline versus FUFA. Sports bodies are indeed amenable to judicial review. Nsamba is actually an advocate, is a lawyer. He took on motorsport, arguing that they had kept him out of elections, they had carried out all kinds of malpractice as far as the governance of federation is concerned. Of course, I tried raising those things. He has not exhausted internal remedies. We are not amenable to judicial review, what have you. But Justice Singiza, as then was said, you receive money from government. And this was even before the Sports Act. It'll be interesting to see what turns out or how these matters pan out when a matter is brought under the current legal regime of sports and how the judges interpret that. Because as far as I'm concerned, I do not think we have a proper arbitration mechanism in place yet. So yeah, they receive government funding from NCS. They're a private body, but conduct matters of a public nature, governing a sport that is important for the well-being, for the cultural and socio-economic existence of Ugandans. Sport, that is how sport is big and is very important in society. So you cannot say that we are private, that because we handle matters private and register privately, we can get away with whatever as far as poor governance of our sports bodies is concerned. Ivan Magomo, similar. Ivan Magomo, for him, it was he had actually properly exhausted internal mechanisms, but he was not satisfied with as far as the protection and safeguarding of his rights was concerned when it came to the internal, because he had been taken on for putting the sport into disrepute and other misconduct allegations, but there were many things that happened internally. As far as he was not given proper notice of the case, he was as far as is concerned. His lawyers were locked out at a certain point, among others. So those rights issues enabled him to go for judicial review, and court has agreed with him. Of course, importantly also, the same argument by Uganda Rugby Union that we are not amenable to judicial review, court said, and we quoted or cited Nsamba. Timothy and I are in that case, and court agreed with us that these are public bodies exercising public functions. But interestingly, the judge referred to the National Sports Act, which is a law that came after that dispute. Okay, so yeah, so those are two disputes. I've also mentioned the Polar in Fufa case, which is a 2009 dispute. That also said that, in fact, at that time, Fufa was saying we're not even registered. An unincorporated body cannot be sued under judicial review. Court said they can't be sued because some of these mechanisms are created to ensure that people, especially when there's an abuse of their rights is concerned, to ensure they get justice. I think even in the Human Rights Enforcement Act, there's a provision like that. You can even take on an unincorporated body and you get your rights safeguarded or protected by court. Okay, so yeah, so you can see that there's a need for robustness as far as the arbitration regime is concerned. It may not be entirely true that courts cannot come in. So I hope people at NCS and wherever listening to this discussion, there's need properly. And I mean, we have had discussions with them, of course, on these things, but I think the way the law has passed, I think also is a bit of an issue, and who was in charge of passing it at the time. Anyway, so away from that. So already there is a mess being created. Timothy and I think, I don't know if I believe when Leon was involved in the compliance aspects, because of a new legal regime, National Council of Sport asked or dictated that every federation must comply, and that involved constitutional reviews, constitutional amendments, among others. So FUFA realized that, okay, we're in a bit of a tight spot here. And I've brought out FUFA because I thought it was the best example. But also FUFA is the biggest sports body. The FUFA guys on call will forgive me. But it's a very good example. I properly studied those statutes. Though there was an emergency AGM recently, but when I checked online, I could not come across what exactly was happening. Apparently they changed some things. But that's what FUFA did at first. So FUFA realizes that, okay, we are members of FIFA, which FIFA recognizes or mandates us in one way or the other to ensure that we comply with the Court of Arbitration for Sport as our final dispute resolution body. But here is National Council of Sport saying all sports disputes shall be handled through arbitration under the Act, which arbitration is final. So they're like, let's pussyfoot around this thing and come up with all kinds of provisions. So they came up with 3 interesting provisions. The first one mandates their members being clubs and whoever is a member, clubs, associations, among others who are members of FUFA, to ensure that their disputes relating to FIFA, CAF, FUFA statutes be resolved through arbitration under the National Sports Act or CAS as per the FIFA or FUFA statutes. As long as it does not violate binding law, whatever that means, very, very, very confusing. So you can see they're now creating options. Go here or here. They also created another provision under 66. What they term now as arbitration. The other arbitration, the first one is for their members, but this one now is FUFA's arbitration. Disputes in the association or disputes affecting leagues, members of leagues, clubs, members of clubs, players, officials, and other association officials, intermediaries, and licensed match agents shall not be submitted to ordinary courts unless the FIFA regulations, statutes, or binding legal provisions specifically provide for or stipulate recourse to courts. Very, very interesting. But well, the devil is because also FIFA statutes also bar or prohibit people from going to national courts. But again, like I mentioned earlier, that is neither here nor there. But ordinarily, if you exhaust the internal mechanisms, then perhaps there could be that option. But yeah, so they came up with a provision like that, barring people from going to national courts. Then it gives an option that such a dispute being taken to either such a dispute can be taken to either the arbitration mechanism under the National Sports Act 2023, or if they are of an international nature, to the CAS arbitration mechanism. So again, you can see they're really just trying to pussyfoot around the place and ensure that they're in the good books of both their regulators, FIFA and National Council of Sports. But like I told you, there's a lot of effrontery, I think is the English word, as far as that act is concerned, in trying to impose itself and say sports is more Ugandan than it is Swiss. We are the regulators, and you must first comply with us. And that is a very, very interesting thing that, without a doubt, will raise so many controversies going forward. There's a third one, which says arbitration for sport, a very interesting term that FIFA decides to come up with. It states, in accordance with FIFA statutes, any appeal against a final and binding decision of FIFA shall be heard by CAS. CAS shall not, however, hear appeals on violations of laws of the game, that is standard, suspensions of four matches or 3 matches, with the exception of doping decisions, or decisions which are appealable to the arbitration mechanism under the National Sports Act. Okay, they're trying to comply again, you can see. So they're creating these options throughout. 68.2, in accordance with the relevant provisions of FIFA statutes, any appeal against a final and binding FIFA decision shall only be heard through the arbitration mechanism provided for in the National Sports Act. Now here, they are more straightforward and are saying, when it comes to decisions regarding FIFA statutes, any appeal regarding them shall only be heard under the NCS Act. Sorry, the National Sports Act. Now, there's a bit of confusion, and perhaps there's a FIFA person on call, and they can tell us what exactly they meant by some of those things. But you could see they were just trying to, as much as possible, pussyfoot and also perhaps cherry pick provisions that perhaps could work for them. And I'm sorry I'm not imputing any bias on FIFA, but yeah, I mean, you can see when it comes to that last provision that those ones can only be handled by the arbitration mechanism under the National Council of Sport. So you can see there's a mess already. There was a first, when NCS first asked federations to comply, they submitted their whatever was requested of them, constitutions, etc. So NCS then came out with comments. NCS was not impressed by these provisions from FIFA and wanted only and only them to be, only and only the arbitration mechanism provided under the National Sports Act to be the dispute resolution mechanism under the FIFA statutes. And that is what I'm not sure was concluded at the recent, what did they call it? It was an emergency AGM or something like that. They conducted an AGM recently on short notice, it was online. So that is what I'm not sure was concluded, and whether they have put everything in line and everything's now going to only NCS. But I don't know if NCS or if FIFA, remember that provision that I mentioned, they just use the word recognize in the act, that they recognize the affiliation of these sports bodies with international federations and that statutes that bind them. They just use the word recognize. They're not saying that the sports landscape in Uganda is bound by them. That's what I've been telling. There's an attempt by that act to say sports is more local than it is international. What I'm not sure, though, is whether there has been any pushback by FIFA or whether FIFA will get into any problems with FIFA. Because, and when you read the FIFA statutes, it's actually true, they create an option besides CAS. They say you can go to CAS, or you can go to CAS, or you can go to what they term as an independent and duly constituted arbitral tribunal. So there's a CAS option as number one, but if you feel like CAS doesn't work for you, then please have a second option as an independent and duly constituted arbitral tribunal. This they stated in the circular, FIFA circular 1010, detailing the standards of what amounts to an independent and duly constituted arbitration tribunal. That if you're going to move away from CAS or FIFA dispute resolution channels, make sure that the option passes these tests of what is an independent and duly constituted arbitral tribunal. And like I mentioned, as far as I'm concerned, that arbitration mechanism, as it is right now, without proper procedure rules, does not pass that test. But let's continue and see what amounts to an independent and duly constituted arbitral tribunal. The principle of parity when constituting the arbitral tribunal. Party autonomy comes in again from our arbitration 101. Has the party participated in appointing the arbitral tribunal? You know how it is in arbitration? One party appoints if there are three arbitrators, you appoint an arbitrator, the other party appoints, then the two arbitrators appoint the chairperson. When you're saying that NCS is going to appoint after recommendations from national sports governing bodies, then you could have a challenge. So that is one principle of parity when constituting an arbitral tribunal. The right to an independent and impartial tribunal, that one speaks for itself. Is the federation, one of the requirements that the person has served with the federation for 3 years or more. A person who has been a legal officer in a federation when they're handling a dispute regarding that federation. But also, you know how the ecosystem is. People know each other and they know each other. So if I'm handling a dispute against one of the sports governing bodies, maybe an issue, maybe a bias issue. Of course, the IBA rules on conflict of interest come in, but on the face of it, it may be a bias issue. Principle of fair hearing, right to contentious proceedings, principle of equal treatment. And equal treatment also means, of course, yes, you have a lawyer and what have you, but also besides for example, in our sports is very communal, and what they call players' unions, what have you. Did the players' unions even participate in the creation of that arbitration mechanism? Can it be argued that at the committee stage, the Committee of Parliament took in all our views? They invited so many people to speak, but I don't know why those views went. Can it be argued that they incorporated, if any players' unions' views regarding the Constitution or the coming up of that arbitration mechanism? There's even a case there. There's a case on that similar subject. So, as far as I'm concerned, and what I'm pointing at in this presentation, is that we need thorough, robust, comprehensive procedure rules for the arbitration mechanism to take place, to thrive, the sports arbitration mechanism to thrive in Uganda. For one reason or the other, the government refused to give us an independent sports tribunal, but government erred and was wrong by stating that arbitration mechanism envisaged under the Arbitration and Conciliation Act should apply to sports, because that act was aimed at different things. Of course, well, maybe they'll amend it soon, but also the act even has things like conciliation, and that's another issue. By the way, you're referring to arbitration, but a lot of sport is not just arbitration. At CAS itself, there's mediation. At FIFA, there's mediation. Here at the SDT in Kenya, Sports Disputes Tribunal, there's mediation. So encompass as much ADR as much as possible. When you only refer to arbitration, there's a bit of grammar. You know, there's a bit of grammar when it comes to this thing. People throw it around arbitration, but it has its bespoke aspects that perhaps, especially when it comes to different areas. For example, you've seen how confidentiality is in commercial arbitration. Largely, things will be confidential. But when you go to ICSID, International Center for Settlement of Disputes, of International Disputes, they publish their awards. I think when we also go to things like the PCA and wherever, they publish their awards. In sports, many tribunals publish their awards. So certain bespoke aspects when it comes to different sectors in arbitration apply. And for you to just copy and paste things may be very, very problematic. So as far as I'm concerned, we do not have a properly constituted arbitration mechanism in place right now. And perhaps, unfortunately, a lot of our disputes are still going to go to court. I know that circular was also, there's been updated over the years, but still around the same things. That if you're going to subject people to a judicial process as a sports governing body or as sports governing bodies, it must, as much as possible, meet the standards that a normal court would have met. And especially because this is a private mechanism. How can you tell me that you're going to dictate for me who's going to decide my dispute? And that's why I had to give you that background of what's happening elsewhere to show you that even the original sports law and how it was has over time evolved. But when you have an act that does not seem to cater for the evolution of sports law elsewhere, we might be in for a serious problem. So the question is, and I throw it out to you people, to your participants, do we or shall we have sports arbitration in Uganda as things are? I've given my position, but hopefully, since the law is a living instrument and can be amended and rules and regulations can be made, hopefully, the powers that be shall realize this. Thank you very much. Looking forward to your questions later.
Great, sure. Thank you very much, Mr. Ivan Ojakol. A comprehensive run through arbitration, not just in Uganda, but the broader spec of things. Indeed, therein was a very exciting presentation. And the question you've left with us is very simple. Do we have sports arbitration as things are? I'll also ask you, the participants, to probably put in your comments through the chat box. Maybe later on we'll get you answering that as well, and any other issues that you may have around the discussion points around sports arbitration. Sports arbitration in Uganda now is catered for under the National Sports Act, Cap 151, from section 55 to 58. Therein, of course, are the provisions of sports arbitration in Uganda. If you haven't dived into that, kindly take time. Now, what are things like on the continent? Mr. Timothy Kaja, kindly tell us.
Thanks, Leon, and thanks, Ojakol, for really paving the way and making my job much, much easier, because that really very much sums up what the basics are. And only my task will be really to add onto the practical interface when we get to the continent. Otherwise, that was a job well done, OJ. Let me just try to share my screen here. Okay. Leon, can confirm that you can see it. Can see the screen?
I can see the screen. I hope our participants as well are able to see the screen. But yes, orange color, sports arbitration in Africa, Timothy Kaja.
All right, thank you. And mine will be really shorter, because really Ivan has done the hard part of it, and I'll only be adding on a few insights that you might want to know if it comes to the practice of the amounts of knowledge that Ivan has laid out for us. And what we'll start with, really the pyramid. For you, if you're living in Uganda and probably you're going beyond these borders, you need to appreciate the pyramid, how it starts from inside Uganda itself, and also that will show you the pathway that we'll see later, which pathway you take if you're dealing with the sports arbitration matter. And in that pyramid, as you can see at the bottom, really, they are the clubs and the athletes. And the athletes, of course, without the athletes, then you cannot have the clubs. And except for those, of course, there are sports disciplines where it's really a one-man or one-woman affair. But largely, those ones, their disputes will either be with sponsors or it will be a doping issue. They hardly have disputes at that level. But if you're dealing with team sport like rugby, you're dealing with an item like football, then even at that level, you can have a dispute. Could be contractual, and majority of them are employment matters. And just also to add onto what Ivan has shared earlier, the particular circular by FIFA and telling them the other option, when you read it in detail, actually it limits those kinds of arbitration to employment matters. So if you're outside employment, you may not be able to go outside CAS if the matter is not an employment. And the background to that is that equally the FIFA tribunal was getting overwhelmed by the employment matters that the tribunal was receiving or is currently receiving, and could not keep up the pace of dealing with such matters. And in fact, that their average time frame to deal with the matter, if a tribunal was widening from the under 3 months, they went to 4 months, 5 months, now can go to 6 and close to a year. So they permitted these national bodies to create whatever equivalence that they can, as long as they are independent, and they laid out what amounts to an independent tribunal. but their focus was purely on employment matters. So it may be disturbing if you want to import into those matters anything beyond employment. But the key point here that even at club level, what they term as arbitration matters, although in practice that there will be really employment or disciplinary matters that are handled at inside the clubs. Now, once you leave the club level, you go to the league level, and the Ugandan leagues, either they are not fully separated from the national association, or they don't have the competence to deal with any kind of dispute. For example, if you look at rugby, basketball, those are not fully independent leagues that can work outside their federations. But yet, if you go in football, you see the Ghana Premier League, it's fairly independent, but it has no competence to deal with any disciplinary matter that is left for FUFA. But if you look at other developed leagues, let's say first the most watched in the country, the English Premier League, they have tribunals or panels that can handle disputes at that level. And when you leave the league level and you go to the region, now the region here referring to the in-country region. The in-country region. Now, not all sports disciplines are that advanced to have in-country institutions or associations. But I think in Uganda, only FOFA has the in-country mechanism to deal with dispute at that level. And even in Uganda, let's say if you go to the Uganda League, because there is Uganda, there is Soga, there is Angola, they have different regions. And those regional leagues are competent to handle disputes at that level. Let's say if it's a regional game and probably it's Buganda region and probably it involves a team from Masaka and probably also a team from Mukono, and probably there's an issue of officiation or there is an issue of discipline. Those issues are actually handled at that level. Now, if you leave the in-country regions, then you go to the National Association of Federations, depending, of course, the Sports Act Cap 151 now separates what an association is and what a federation is. And even at that level, now that's where most of the discussion that we had in the earlier session with Ivan was centered. So at that level, there are of course panels that handle disputes depending on what level you're bringing in that dispute. Either is it an appellate, is it is it a first instance matter? You can also handle it at the national level. Now it's from that level where the National Council for Sports and the Act have also imported that the arbitration under the Act, because they don't give us a particular tribunal, so just describe it as the arbitration under the National Sports Act. And we'll wait to see the list of arbitrators that the minister will be putting out. But that's where they come about. Now, once you leave that national level, then you're going beyond your national borders. And depending on the particular discipline, you go at the continent or you go at the subcontinent. So it depends on what discipline it is. And even some of the subcontinental associations may also not have the competence to deal with some disputes, or if not, or actually you find that disputes that they'll be able to deal with are those that relate to the violation of their particular statutes. And for this part of the world, I think the most famous subcontinental is CECAFA. So CECAFA is the one that runs football in Eastern Central Africa. But you can see that you cannot have your matter. Let's say you're appealing from FUFA, instead of FUFA, you're going to CECAFA. No, you cannot do that. But if there is no subcontinental level, then you go to the continent. And in the continent, you find what they call confederations, like CAF, that's the confederation. It runs the continent. And you find that even those similar to the subcontinental, even at the continental level, they really don't have the competence to handle a dispute of any discipline, in spite of the level of that discipline. The only thing that they can deal with is a dispute that concerns their own statutes or their own leagues or their own tournaments that they organize as as a confederation. And I think we can all easily remember the chaos that befell the AFCON finals, men's finals that happened earlier this year between the chaos between Senegal and Morocco. So the reason why it went fast CAF is because the tournament was organized by CAF. Otherwise, if that wasn't the case, then it would have been going straight to CAS. But as Ivan has said, if we had an ad hoc division handling any disputes at CAF or at the AFCON, probably then we wouldn't have seen that chaos. And we'll get back to this later. But the point is that at the confederation level, they are only competent to handle matters that concern their own tournaments or their own statutes. Now, after that, once you leave the continental level, then you go to what they call the IFs, which are the national federations. And the national federations, of course, most separated are FIFA. We have the likes of FIBA, if you're going to basketball, the FIA, if you're in motorsport, and the like. And so often those two do not have the competence also to handle appeals. So it's also something that is interesting, that even if the decision was made at national level, you cannot appeal it to FIFA. For example, if you look at football, you cannot even if the decision was probably probably one season ago when we were handling the KCC in Barara and then FUFA. After the decision by FUFA, we could not go to CAF because it's a confederation, but we also could not go to FIFA itself. You had to just go straight to CAS. Why? Because even FIFA has a tribunal, but that tribunal is only competent to handle violations of FIFA statutes and also any laws that have been created under FIFA statutes, but they will not handle your appeal from the national level and say that public appeal to us. They don't do that. They want to deal with only their matters. Although, like we said, there are some sports disciplines that would permit such appeals, where they can hand an appeal from a national sports association to a continental or to a world international sports association. And then above that pyramid is the International Olympic Committee. Now, for the International Olympic Committee, this is where most of the sports disciplines that we know of are kind of convened. And it's the IOC that is seen to be the de facto head of all sport globally. And this was also made by even the politics of the world, that even the UN General Assembly gave the IOC international observer status. That means that they can work with, and you see that the IOC will go on and work with other international bodies, let's say the United Nations Office Against Drug and Crime, the International Organization on Migration. It works with many UN bodies because it has observer status. It's not a member state, but that is how strong sport can be, that it has, literally, it can do what other countries can do at the UN General Assembly. Now, it's this that then, because of that, and in agreement now, going outside the pyramid, as you can see on both sides of the pyramid, there are other institutions that are outside the pyramid, as we can look at it. And one of the institutions outside the pyramid is CAS, which Ivan has already broken down for us. Now, CAS is nowhere in that pyramid. It's not a national body, it's not a international body, not a confederation body, but IOC undertook to also recognize CAS and also request is putting it mildly or kindly, but mandated all those bodies that want to associate with the IOC to also recognize CAS and its decisions. And because of that, every Olympic sport also subscribes to the Court of Arbitration for Sport, but it's an independent body. In fact, if you look at it, it's also an international NGO. If you look at it, particularly, and how it's operated in Switzerland and why it went there, is that now IOC recognizes, he says that now if you want to also be part of us, you also have to recognize CAS. That's how many go there. But also important to know that not every sport is an Olympic sport. So the sports in the non-Olympic sports are actually not forced to subscribe to CAS. And those that do subscribe to CAS either do so because they want to be recognized by the IOC, and IOC will say, okay, you're who? You're dance sport. Oh, dance sport. What do you do? We are dancers. And you say, you want to be at the Olympic Games? Yes. Okay, number one, first go and organize CAS. So they will do that. But even there are those like esports that just say that no, I think in our case, we need not be there mandatorily or fully, but let us recognize CAS because probably of the goodwill that CAS has built over time. But this is a body outside the governance sports pyramid. Another body similar to it is, of course, WADA that deals with anti-doping, similar to it. So these are independent institutions, but the contributions from WADA, these are some of the members when I think at the end of last year, the US as a country pulled out of funding WADA because they thought that WADA was not observing some of the positions that US was subscribing to. But it's an independent body where even countries are forced to not, are mandated, probably a better word, are mandated to contribute money to WADA. Because in CAS, you pay money to access CAS. The minimum should be now around 20,000 Swiss francs. So you pay money if you want your matter to be dealt with by CAS. The exceptions, we'll see them later. So that's how they get money. But WADA, you want to, it's WADA that comes to DOP. So people go to CAS with disputes. But WADA and the organizations under WADA are the ones that come to the athlete and say, you've performed well, but we want to be sure that this is not artificially induced. So they'll come and double check and see whether your good performance is indeed good performance and you have not used any prohibited substances. That's why WADA comes in. So WADA is not something that people would want to voluntarily subscribe to or pay money. And now in Africa, it's even worse. I think Africa's contribution to WADA was cut down to as low as 2%, but still Africa could not contribute even that 2% of WADA's fund. All African countries had to say. I think by the last time, by had a summit last year, the Africa's contribution was at 0.5%. All African countries contributing to WADA 0.5%. That's why you see our testing levels are low and everything, because we don't fund enough. And of course, that's changing. Even then, we're establishing a national doping committee, so probably that will change over time. But still, our numbers remain low. But that's what it's also independent, but it does that. And if you dispute that, if you dispute any decision or any finding by WADA, then you also have the right to appeal to CAS. But these are independent bodies, and even there are some it should be starting last month into this month. They're what they were called the enhanced games. These were athletes who are competing in the USA, and these athletes were doping, or they are allowed to use whatever substance that they use. And if you think that Usain Bolt is the fastest, or this person is the fastest, or Joshua Cheptegei is the fastest, you can go and look at the timings that were being posted in those games. They were ridiculous times. You should find that these records that we know are no match to the numbers that people were posting in the enhanced games. But that is another story for another day of how then an athlete can be able to be that super efficient. But again, why the laws do not permit athletes to invest in being super efficient by using artificial enhancements in the form of doping, but it's also independent. Unique to Africa, we have the African Union Sports Council, which I'm happy to work with. Now, this is also a body that is governing sport on African continent, but it's not organized by these international sports federations. As a matter of fact, even the IOC is pulling ropes with the African Union Sports Council because they're saying the Africa Games, which if all goes well, Uganda will host in 2031. I don't even, if you win anything in the African Games, the IOC even does not want to recognize that you've won anything. Even they look at you like an amateur athlete, and that's why you see many of our athletes even are no longer competing at the African Games. But because that is unique to Africa, but that's also another body that was set up by the member states of the African Union to promote sport on the continent. But it's also not being recognized in there. They also recently, I think at the start of this month, they had, and end of last month, they had their, what we refer to the AGM, and they passed new regulations, which I was happy to be part of, that will be governing the African Games. And in those regulations, we put a provision for the ad hoc divisions to handle any disputes that may arise at the African Games. So that is an opportunity that you may want to look out for if you want something to bite on in the world of sport. The games they're happening next year in Egypt first, but after that, after the Egypt Games, it's coming to Uganda. So at least if you miss Egypt, there will be a chance for you to do something in 2031 because those regulations were passed, and so there's an opportunity for us to do something in the world of sport. And also now, because this coming back to the pyramid, this is seen as professional association sport. Now, on this side of our pyramid, where you don't have the WADA, where you see the Airtel Masaza Cup and the European League now, there are other tournaments that do not recognize, they do not associate with association football or professional football, but they organize their own tournaments that have also really gotten some mileage and goodwill over time. And in Uganda, of course, we know the Masaza Cup. We are seeing that even certain regions in Uganda are replicating that in Busoga, in the Ankole region. Actually, the Ankole version is ongoing right now. It's the first edition happening this year. So you can see that there are people who organize sport, but they're not part of the mainframe pyramid. And also internationally, the best known is the European Super League, when they tried to come in and to come into the world of sport and probably overtake UEFA in organizing another version of the Champions League, which was the European Super League. Of course, it failed, but it's not yet done and dusted. I just wanted to have a proper view of this pyramid so we can know where it starts from, where we want, and where probably would want to go. Now, knowing that that pyramid, of course, now you ask yourself, what are then the arbitration pathways in that pyramid? Like I said, there are what they call the first instance matters. And like we said, these will come from whatever stage you are, whether you are at CAF, whether you are at FIFA. When you violate the internal statutes of any federation or confederation or association, then that even if you're Ugandan and you violate a FIFA provision, we don't start in Uganda. We just go straight to FIFA because you've violated their internal statutes. We don't need to come from Uganda to go to FIFA. We just go straight. Also, if you violate competition regulations, we don't take you lower or upper. We start at the very competition. That's where your arbitration happens at. Then after that, there are an option for appeals. And of course, the appeals, the appeal masters in all of sport is CAS. I've already seen a whole lot about how CAS goes about that. But when we get to the CAS level, you appeal to CAS if your statute permits you to appeal to CAS. If not, you could go there ad hoc. Ad hoc means that we find yourself and we have no other alternative, we can go to CAS. Or even the ad hoc, as Leon told us in the introduction, the ad hoc divisions are also being created at particular tournaments, and the latest being the one that is at the World Cup. Of course, there's a lot of drama in day one. Anyone who's not happy with that drama can go to those ad hoc divisions, and under 24 hours, they'll have their decisions done. And like I said, even the African Games are introducing these ad hocs, and we hope that many divisions will adopt these ad hocs. But even though you don't have anywhere any provision users that permit you to do that, you can go to CAS. Also say that we are it's a first instance matter, but we cannot go anywhere, so we are here at CAS. And then CAS will be able to entertain your matter to start from its CAS first instance division. Like I said, not everybody subscribes to CAS. Some are partial, some are not part of it. I've given some examples. World Boxing, they're not part of the IOC. They're not part of this. It wasn't an Olympics, but they fell under the IOC, so it's not currently recognizing CAS. Neither is it recognizing IOC. Actually, the IOC is kind of setting up its artificial boxing association. Esport, they are partly there, partly not there, because probably they're saying that the CAS don't have the expertise to handle esports matters, but CAS is kind of changing that, having esports people in there. Probably one of the people who that they first introduced on esport is East African girl just down in Tanzania, a gentleman called Peter Mshikila, who's also now part of CAS, but from the esports wing. Also the American closed leagues, because America, remember, but America's leagues are not about promotion and relegation. They run their closed leagues. That means they are franchises. The New York Knicks want to take their first win really in probably over half a century. But they have, even if they have been doing bad over the past decades, you couldn't relegate the New York Knicks because they're in a world of their own. And if you have any matter that is a problem in the NBA, then you close it at the NBA. NBA also has its own ADR mechanism, so you can take your matters there. Also similar to the golf PGA tours, these PGA tours, actually their version of sport is similar to the European Super League, that they create the best of the best, pay them money, and have them play. If you have a dispute, they also handle it internally. Then you cannot see probably Tiger Woods, all this probably running to CAS. No, they don't do that because theirs is private, and that is the American approach to things. They want to settle their matters in there. A few of their sports disciplines will give you an avenue to CAS. That is majorly for the sports that either they want to be recognized by FIFA, a bit of football in MLS, but not the college sport. And there you can also go to CAS, but most of it, they have their collective bargaining agreements, they have their American courts, they have also their internal dispute mechanism where they have their disputes in there. They also look at it as arbitration, but internal and unique to them. Another thing is they also call it, it's unique to sport, they call it arbitration, but especially when the dispute is more on ethics, someone violated an ethical standard, let's say corruption, probably sexual assault, the way you conduct yourself, language, professionalism. Now, in there, they have two chambers, most of the sport disciplines, including football, is that they'll have what they call the investigatory chamber and the educatory chamber. And I've had many people in Ghana, they say there's this issue of Honorable Magogo being a parliamentarian on the NRM ticket, yet he's also president of FIFA. And then they say, we've gone everywhere, we to CAS, because we turn to CAS, we turn to FIFA. It's because they are writing at the wrong forum. Because if you have any matter like that is a matter that concerns ethics, then you actually first go to the investigatory chamber. And that's so you make your complaint, you file your complaint at the investigatory chamber, and it's them to investigate. And when they investigate and they find that there is cause for a dispute, then they go and then take it to the adjudicatory chamber, which is also something they call it arbitration, but consider these are unique facets of arbitration that probably are alien to the main domain arbitration mechanism that we know, but how they handle their matters. And then even when they're adjudicating over a complaint that you have raised, you may not even be invited. So you may lodge a complaint and they do their things internally. You're not invited. You're not even invited, given a chance to make your case. You will just see that they have given a ruling for or against your complaint, but without you being fully involved, the only chance that you have is you to raise your complaint. That means that if you want to say anything, say as much as possible in your complaint, because you may not have a chance to make any additions to your case. Yes, also the key issue also to note, mention what we've already seen by Ivan, of whether we have no direct arbitration agreements. Of course, we know that in arbitration, if someone brings him and just, oh, where is the agreement? Where is the clause? Here it's not there, you won't find that. Ivan has already told us that. Then there is use of portals. I said most of the things are filings, e-filings. Good enough now in Ghana we have ICMIS, very similar to ICMIS. That's how they largely deal with their matters. A few of them still accept emails, but often the person will tell that if you file emails, it may take ages before you get a response. So they are more active on portals than on emails. Then they have no standard formats, whether it's because it's a practice where it's international practice where we have many people from different backgrounds. Whatever standard format you bring, as long as the substance really makes sense, they won't matter what format you've used. Then third-party funding, which is a very key issue in arbitration, it's not regulated, but in practice, it does happen for those who cannot afford. They can go for third-party funding, absolutely no problem. Actually, there are even companies whose role is to buy disputes at cash. If you cannot pay, for your cash, because one of the issues is that the cost at cash is very high. If you cannot fund your matter, they'll have your matter at cash, they'll pay for cash, and then wait for the win. When the win comes through, they get their cut plus interest, and then they give you the balance. But if you cannot find that funder, then there is legal aid. So of course, it's they say finance is the big question and kicks out many Ugandans. But you can apply for legal aid. We've applied for 2 Ugandans now. One did not succeed, the other did succeed. So even when you cannot afford the legal fees, you can still apply for legal aid. And also another issue to use because of the international outlook of things. Just in addition to the case that Ivan has shared with you, I've added for you the Penaro case. I said now, because we are dealing with matters from all over the globe, even if it's a local dispute, let's say if you begin with a matter of the local dispute in Uganda, if you graduate it to CAS or at FIFA, we will not be following the laws of, let's say, you say that it will be followed by the laws of Uganda or something. If there's any conflict between the laws of Uganda and the FIFA statutes, which you've already seen, of course, there's even a conflict of whether the matter should stop at CAS or it can stop at NCS or it can go up to CAS. The law that will be paramount will be the international framework. They do that because they want uniformity. So every time you bring your laws that are unclear here and there, they'll just forget your national laws and they'll go with the international provision, which in ordinary arbitration may be problematic because if the parties choose that us, we are being bound by this law, and then it's hard that arbitrators say that although you guys have chosen to be bound by Kenyan law, I'm going to apply South African law. You cannot find that in the ordinary arbitration, but in sport, you can very much find it. And then the multiple language option, that means that if you wish to work in these spaces, English is not enough. English is not enough. And of course, when I say English, that doesn't mean that you add another local language. So you add Lusoga or Uganda or Nyachitara. You must add an international language. You must know a bit of French, a bit of Spanish, a bit of Arabic, now a bit of Chinese, a bit of Spanish. Having these languages is an asset because you will find the last matter that we worked on dealing with a guy who's based in Mexico speaking Spanish. So if you don't understand any bit of Spanish, you're going to struggle to understand the arguments, you're going to struggle to raise counter arguments. And your client may lose your case simply because the only language that you know is either Uganda and English. That's not enough when you come into this platform. You must get a bit of language, irrespective of whether you may say public. Of course, you may say public. Of course, ordinarily, the language of arbitration shall be English. That doesn't work in sport. In sport, you'll find you'll come to sport, you go to a tribunal, and you find that in one case, they are using 3 languages. So you who's poor in terms of language or linguistics, you're going to either struggle or you're just going to lose the case in whole. So it's important that you may not be an expert, but you must know some terms that you can easily follow, or if it's interpretation, you can easily catch up because even the interpreters are not as perfect. Yeah, I think that many of the things really happen online, so you don't have to struggle with movements here and there. It's very difficult that you find a matter that will require your physical presence, but many of these happen online. The other one is, which I've already talked about, that if you have any ethical issues, instead of raising them as an arbitration, you raise them as a complaint, and then they will be investigated. The challenges of resolution cost is very expensive. You need at least 23,000 Swiss francs for you to arbitrate any matter that will be in the region of 80 million to 100 million, which is not many sports men and women can really easily afford that. So the cost is the problem. But like I said, you can go for legal aid or you can ask for third-party funding. Then the quality of arbitrators at national and confederation level, because these are appointed by politicians who make these appointments as political rewards. So if you have someone who supported you in winning an election, make them an arbitrator. Someone who's someone's son, make them an arbitrator. This is not really at CAS, but I'm saying at it's often at national and confederation levels. I think you saw the quality of the ruling of the CAF panel on the Senegal-Morocco matter. So it was really one of the key issues was really the quality of those arbitrators. And these were really political appointments who have no very knowledge about sport and really sports arbitration. It's very similar to political interference, which in that even it's not Uganda. Now, if it is the minister appointing you as the arbitrator, then it's a question of whether if that minister makes a call and say, please, this award should take this route. It's hard for you to really say no to that because you've been appointed by that minister. That means somehow, somewhere, they could have the power to disappoint you, which is a downside in the arbitration where we know that the parties have autonomy to appoint the arbitrators, which is absent in sports arbitration. And his first stops, Ivan was already talking about, is that in that NCS is forcing our arbitrations to stop at national level, which of course is in conflict with the international framework. So that means that there won't be business for you or for us beyond these borders. But it's something that I'm sure will be challenged, and we'll see what comes of it. And of course, there are challenges in enforcement, but Ivan has given us some leeway out, let's say, under the New York Convention. But also, if it's sport, depending on the discipline, FIFA is very advanced. And Ivan, I know you mentioned about the FAD bio case that went to CAS. So just news for you, we won that appeal, but now we're at enforcement stage. And because the clubs are vested in check, the enforcement is happening through FIFA. So FIFA can help you enforce these awards. And if someone fails to pay your award, then the transfer ban is implemented, because then they just coordinate the federation in Uganda, FIFA, and the federation in Czech Republic will then bring the pressure by in way of bans, transfer bans, and payment bans to that club, and that money before the club pays that money, they won't have the leverage to that. Also, another way is that if there's any contribution that FIFA or the mother association is going to make that club or association and they haven't paid you, then FIFA does not pay them. They just pay that club's money to you. So there is enforcement. But that is unique to football. Other sports disciplines is really still a challenge. But I know others are picking up and learning from FIFA to have such an international framework to ease the enforcement channels. And solution opportunities, of course, we've already mentioned having sport dispute resolution institutions. We have one in Tanzania where we can learn from each other and train arbitrators. So that by the time an arbitrator puts out an award, you can really see the quality in the award, and that follows with the capacity building. So if having these institutions, then they can help us in the capacity building. For example, CAS has annually, it has their conferences and seminars. That means that it keeps their arbitrators updated and sharp on these cases. And of course, there's exclusion clauses. If athletes are not well advised, someone can insert an exclusion clause barring an athlete from taking any matter to a would-be proper channel for arbitration. And then that leaves, because often if you want to go to FIFA and there's a clause that stops you from going to FIFA, then FIFA also cannot entertain your matter. They respect that. So if you don't advise the athletes well, and those clauses are inserted, then it becomes difficult for them to access justice. Then awareness, and I would say thanks to CIAB that we're having such opportunities. This gives us a chance to spread awareness and also engage the stakeholders and have some feedback on that. That's all for me. Thank you, and back to you, Mr. Leon.
Wow, thank you very much. Thank you very much, Mr. Timothy Kaja, for that very illustrative presentation. It has taken us actually through what CAS is like and what all the other aspects are like. I will come back with a few pointers that I've picked from both presentations, and I'll be asking the questions therein. But for some of the comments that have come through, I would like to read quickly. Baja Rukia here said that sports disputes is not even defined. Council Jaco responded and said, yes, Well, there is a very ambiguous definition, which is, to be honest, with the nature of sports disputes and jurisprudence, which does not suffice. And indeed, as per the statutory instrument of 2025 National Sports Regulations, sports disputes are defined to mean a disagreement relating to the interpretation or limitation of one, the act, two, these regulations, or the statutes of national sports organizations. And it only stops at that. And so definitely, does it suffice? That, well, your guess is as good as mine. Odeke constant. Party autonomy through arbitration is built on party autonomy, meaning both parties voluntarily consent to the process. The Ugandan framework enforces mandatory arbitration, very much the same and elsewhere as had been highlighted with the cases that Councillor Ojakol spoke to. Anania Dondole. I am currently studying an LLM in ADR, and we are having a session on sports arbitration. This session is an eye-opener to me. You are welcome indeed very much to that and many more that we actually hope we shall have. Again, OC or Odeke here says, to align Uganda's arbitration framework with international sports arbitration laws, the country must reform the Arbitration and Conciliation Act and harmonize it with the newly enacted Sports Act. Well, I don't know which one would take would prefer to do the other, but nonetheless, currently Uganda's primary arbitration law is built for standard commercial disputes. Yes, that had been highlighted, which fails to accommodate the unique lightning fast requirements of Lex Sportiva, global sports law. George Senfuma is asking for the contacts. Yes, those contacts will be shared to you. Patricia Yebare, this has been very informative. You are very much welcome. And it's great being part of this. Valerie Kawangu, great presentations, energetic and knowledgeable speakers. Thank you very much, Mr. Ojakol and Timothy Kaja. They're in for that. Diving straight and within a few minutes we have on us, one or two questions. You spoke about language. Very interesting. I surely should be dashing to learn French or, if anything, Spanish immediately. Martha or Wembabazi, this is great. You are welcome. Mr. Kaja, quickly, you have been through the judicial processes of local sport, specifically football, where one, you have a case, first instance, then appeal, then you proceeded to CAS. It had been earlier highlighted by Councillor Ojakol that, yes, the processes in football are quite defined. What do you see of other sports federations in this country and their judicial structures, and what then needs to be enhanced to ensure that we, as a sporting fraternity, are able to deal with these disputes in the procedural manner that is required of us? One, and quickly, I'll dive to a recent issue that the Uganda Volleyball Federation, two clubs submitting a dispute to the National Council of Sports, the National Council of Sports telling them, go back and deal with this matter internally. Do our sports federations have just good enough judicial structures to deal with sports disputes?
No, like I highlighted, one of the major challenges at national and confederation is the quality of arbitrators. Ivan will tell you here, when you're handling something that I want to mention locally, where you have a would-be arbitrator taking on the respondent directly, accusing them here and there, and they will even leave the case and then they will go to personal issues. And this will be done by someone who would be a panelist, the head of probably the chief arbitrator, but he or she is the one who's inciting anarchy in the panel. So even we're dealing with some matter at FUFA, and we're dealing, and there was a lady who was ending the panel. I tell this, and the matter concerned concerned a yellow card and a red card. So we were there arguing like for 1 hour, and she stood up and asked, by the way, what is the meaning of a yellow card and a red card? She had no idea what what those things were. So we're wasting time because the person does not have the skill or the knowledge, and not even interested. But they are appointed as a political reward, of one reason or the other, and they don't have really the skill and the knowledge to handle this matter, all such matters. And then you find that the people will make very funny awards. You find an award on even a quarter a page, after probably deliberating for about 3-4 hours or days. So the problem there is the quality. But even when you get to accusing them of the quality, then they ask you, where do you get them from? Because they were saying we have no sports lawyers around. So what do you expect us to do? You guys come here, someone you bring a matter, their constitution say that they must have an arbitral panel, they have no arbitrator, so they'll call their friends. Some of them dealing with the matter where someone the association president had a friend who had done a diploma in law at LDC. And then he called down that person. The person, when you read the person's award, so the question is really about the quality of the personnel that we have. But we hope that when we're having such interactions, and we're also having, we're growing the human personnel. Look at the people who are on this call a few years to come, because if the FIFA guys or the CAS guys did not start with that quality of people. So it takes time that then if we have also local arbitration, we have these matters that are being presented, they're eye openers. They test us, they test the quality of our systems. So we may not be doing bad, but we're not in the best place. But because we are having engaging in this webinar, then we hope that it's only a matter of time that we'll get good quality arbitrators and who will give us good systems and then potentially amplify access to sports justice in Uganda.
Sure, thank you very much, Mr. Kaja. Now, for our participants, just to let you know, actually, East Africa has a handful of arbitrators at CAS. Dr. Don Rukare from Uganda, he is also at the UOC and the Commonwealth Games. I believe all of you know who Dr. Don Rukare is. He's an arbitrator at the CAS. Then Peter Mushikilwa, who Mr. Timothy Kaja had made mention of, newly appointed a couple of months ago from Tanzania. And also Senior Counsel John Ohaga from Kenya, who has been in charge of the Sports Dispute Tribunal in Kenya. Those are the three at least I could pick up quickly on the gentlemen that have now placements in sports of arbitration for Court of Arbitration for Sports from East Africa. In Uganda, though, to where we start from, the Sports Act under Section 55(6) requires that a person shall not be qualified to be appointed an arbitrator under Section 1 unless that person is an advocate of the High Court or has worked with the National Sports Association or National Sports Federation for at least 3 years. Things that Mr. Kaja has been speaking about, the competence therein, and this is where I would want to bring in Mr. Ojakol. Do we need the training? Who will do the training? Who will take charge of the training? Mr. Ojakol.
And I'm going to say it's here because I can see there's some quite competent and qualified arbitrators on call. There's this person who once posted something controversial on Twitter. I think it was Ivan, what's his name, the former journalist, Ivan, young man, the lawyer. He said he cannot give an arbitral appointment to a non-fellow of CM. And I get what he meant, because there's a certain rigor that people go through those training to achieve. So yeah, there's a training issue without a doubt, and perhaps because largely a lot of these arbitration institutions have been for a long time focused on the commercial space and the normal arbitration, and they forget there's a larger, a whole different area of sports arbitration. Not very, very different, but the low-hanging fruit that they can tap into, especially because of the nature of sport and how much young people are involved in it. But also there's a wider question of the governance sports issue. Timothy, of course, has mentioned people reward their people, but also the ecosystem. We are an amateur ecosystem. I can assure you, even as much as, yes, people are rewarding their people, but you'll find that there's a small pool of volunteers to pick from. Someone is already, it's an amateur ecosystem, people are not being paid, then inevitably someone says, Ivan, you come and you sit on this disciplinary panel, but Ivan already has all kinds of biases whatsoever. Maybe he's already chairman of a member of the association or a club. So when he sees this player who he doesn't like, or if this player is gotten off the hook, they'll come back and punish his team or something like that. So there's a challenge which we suffer from in this part of the world as far as the amateur nature of sport is concerned, and hopefully slowly we'll get there. But yeah, training without a doubt. Of course, there's bespoke sports training. You can mention a couple of institutions. Sports Law Hub, CAS has started. I think they have a summer program coming up in July. ALS, Academy of Leadership Sciences, Switzerland, has a couple of online programs. But I think for me, blending that with SIAB training or normal arbitration will take one a very long way. That is what I think, yeah. Because there's something about SIAB, and I hope you guys will give me some. I don't know. I hope Bridget will send me some Kasim for vouching for it. But yeah, I came to appreciate the quality and rigor of training, which is a bit different. Yes.
Great. Thank you very much. I've also been reminded, Dr. Emilia Onyema. Yes, Dr. Emilia Onyema, therein also recently appointed to CAS. Mr. Johnson Were says, thank you very much for this. I hope sports leaders are here for them to learn. Indeed, there is quite a lot for them to learn. What are the various training platforms our officials can attend? That is Angela Namirimo. Yes, Angela, there is an introduction to CAS arbitration. The registration closes on the 15th of June. It will cost you approximately $500. That is the more recent training course you could have. You could also look out for Sports Law Hub. They have an intense course in sports arbitration before the CAS. It is also open for registration. Council Jakol has made mention of other platforms. And for the future, I must tell you that SIAB will come up with a program, considering that now we have started this kind of conversations. The same had started before with the National Sports Arbitration Moot. Timothy, would you want to talk about that? Because you have been at the forefront of pushing that moot for budding law students to get involved in a sports dispute education and also basic practice for starters.
Yes. Just summarily, we are still working on that mode. We hit, of course, some funding constraints, but not all hope is lost. So probably when we call upon you, or we put the ad out, probably even since Madam Anna Mara is here, she can give us some money. And we host this thing because we are making progress. And of course, we hit some funding wall, but we are hopeful that we'll get it back on track.
Well, great. Hopeful that we'll get that back on track. We have just a few minutes, but to wrap this up, gentlemen, Mr. Ivan Ojakol, your final words, and therein you may have said earlier that we don't really much have the sports arbitration framework, but just how much more can you emphasize the need for sports arbitration in Uganda and possibly the direction we can take as a continent?
Yeah, we without a doubt need sports arbitration because I think one of the major stumbling blocks as far as the professionalization of sport in this part of a country is thorough, definite, robust, comprehensive dispute resolution frameworks and forums. People throw around, we have an arbitration, you come to an internal judicial body, and all the problems that Timothy has mentioned, and the ones I've mentioned will always accrue. Before you know it, your client has not got justice, before you know it, you're in a court of law for the next 5 years over a client whose career, he's about 30, and before you know it, he cannot play for the next 5 years because the federation said you're not going to play. So we have issues like that. So without a doubt, for me, and also largely, what is sports law has not been appreciated. And I'll give you this example, and Timothy perhaps also knows this. A sports federation president will look for his lawyer who has been doing his B100 transactions ahead of you who has an NLM. Of course, some of those problems are also inherent to sports law because of so many contradictions. And I mentioned some of them coming from Europe and elsewhere. But I don't know how so-called sports lawyers we are going to position ourselves to properly tell guys that we are the guys. Because some of the problems, like Timothy has mentioned, that CAF decision of Morocco Senegal was because of a lack of proper training. These are lawyers with normal legal minds. They have come one-on-one legal. We apply the law. And because of that, they're missing out certain nuances. So perhaps we should also maybe maybe Leon, you and I and Timothy have not done a very good job in marketing ourselves out there, but we need people with specialized training in this area. And that is the only way we can achieve some level of sport justice. And beyond that, I think there's need for either a bar bench meeting or awareness of the judiciary, because many times you go to a judicial officer, the moment he sees a sports dispute, even if you try and explain, these guys, we went to them, internal sports resolution mechanism, it did not work, he or she will immediately think of an ADR no, don't worry, I'm waiting for a mediator. No, I cannot handle this. Before you know it, so there is that bias. So we need a certain level of awareness, training, and creation towards the bench, beyond us who want to go into this private dispute resolution mechanisms and what have you. The moment you go to the bench, you get the bench on board, trust me, because like I mentioned, as far as I'm concerned right now, there's no proper arbitration framework, but beyond that, courts can intervene in certain circumstances. So those are my petitions.
Thank you very much. Maybe just a quick one. Have you seen the recent decision at appeals for CAF rather, Senegal,
Man,
Morocco, Senegal?
that's another issue we have now. I mean, how can you not publicize something like that? Clearly, there's a lot of manyanga somewhere.
Yes, so yeah, it says a lot. Mr. Timothy Kaja, kindly your final words. Arbitration, sports arbitration in Uganda, Africa. Is the future bright, bleak, or probably something that we should be very hopeful about?
Yes, of course, we are not where we want to be, but definitely the future is bright. And what I would tell our colleagues on the call is that the opportunities are there. You have to hunt them down, but indeed they are there. They may start, of course, the remunerations may not be as good as probably you wish it was. Like, let's say international commercial arbitration, where you have the big matters involving state parties. But still, we're getting there. Like I said, the opportunities that are coming up, and it's because of this awareness, and it's because we have to get into some decision making spaces. Like I've told you, the African games that are coming, they're going to have ad hoc panels. And of course, they don't have the budget, because then it will be the host country to fund the arbitrators to come to Uganda. But why should Uganda pay someone from Switzerland to come, yet you're there, or yet you're here? So it's about really, we need to do the skilling, and then take up these opportunities. These opportunities are boundless. You can do everything online. All you need to do is, of course, you have to put in the hard work. If you need a bit of skilling, you must be proactive, get the skills, get the knowledge, and they change. Sports laws are like tax laws. Every year there is a change. Just going to the World Cup, even before the World Cup, there are changes. And so if you just leap for a month and things have gone. And so you need to keep learning, and you need to keep skilling, and then you have to look for opportunities, and don't fear to take them up, because you can do them remotely, even if you are advising whether it's a club is in Manchester, or it is in Jinja, or it is in Cape Town. You can do all of that only by the press of a button, and you can be able to do this. But of course, before you do this, because there's no need for you to rush, look for the opportunities before you get the skill and the knowledge. For now, we are still at a nascent stage. So we have many doubters to prove wrong. And this will pose a challenge. And how we do that is that you have to put in the skill. And I want to thank CIAB that they give us opportunities to share what we can, and also be able to also update ourselves and learn from each other. Those are my parting shot, my friend.
So thank you very much, Mr. Timothy Kaja, Mr. Ivan Ojakol, for what I must say has been such a fruitful 2 hours of interaction around sports dispute resolution. The webinar today was entirely about the practical insights into sports arbitration in Uganda and elsewhere in Africa. I believe you indeed have a full pocket of knowledge on what the insights are exactly like. A little bit more, you can get in touch with all the contacts will definitely be shared with you through the emails that you used for registration. From me and everybody else, I'd really want to thank the Chartered Institute of Arbitrators, the Uganda chapter, for this opportunity that has been granted to the sports sector. We look forward to many more of these. And I must say, the training opportunities, we are coming with a full module or modules therein with regard to trying to enhance the sports law and arbitration knowledge around this particular space. You can still follow CIAB on their socials, on X, LinkedIn, YouTube, and Facebook as well, and also check out their website. Ladies and gentlemen, it was indeed a pleasure having you for this particular session. Till we meet again, have yourselves a lovely evening and enjoy the World Cup and mostly local sport. Be well and be blessed.